So I'm going to call up the next panel. And then after our next panel, we're going to have lunch, and it'll be served out in the front. We have gluten-free options, vegan options, and we're going to go for about an hour, and then we'll have lunch for about an hour, and then we'll start up this afternoon around 1:15-ish with our legislative panel, which is also going to be fabulous. But first, let me call to the stage Mr. Lee Taft, Mr. Nicholas Guillory, and also Mr. Mitchell Katine. And they're going to talk to us about Lawrence versus Texas. And I am not going to belabor the introductions so that they can get right into the heart and the meat of what we're going to talk about today. And to all the folks on Zoom, please do reach out to us. We have our emails will be available to you all, and then you can also see as the screen is rolling for the folks who want CLE credit, the CLE number is up there. It's 4 hours of free CLE credit plus 1 hour of ethics credit.
Good morning, everyone. I'm so glad to be back here with my Lambda Legal family and the many supporters of LGBT rights. When I first sought out to be a Tyrone Garner Memorial Law Fellow, named after Tyrone Garner, the lesser-known plaintiff in the case Lawrence versus Texas, I did a little bit of research myself on the case, and I thought I knew everything there was to know. A couple of years later, I actually was on a actually watched a panel with Mitchell and figured out I knew not even a fraction of what there is to know. So I'm very excited to be here today with both Mitchell and Lee to kind of help share with you all Lawrence versus Texas and the effects it has had across the state and the country. It was very important for me in my work and also me personally as a lifelong Texan and a queer trans man. So I'm so glad to now pass it to both Mitchell and Lee to kind of do a little introduction. Let's start off with, I guess.
See if this works. Okay. Good morning, everyone. I'm happy to be in Dallas at this Lambda Legal event and at the Holocaust Museum. I'm from Houston. I had the honor of being John Lawrence and Tyrone Gardner's local counsel, private attorney in Houston, and you'll hear a lot more about that today. I'm a practicing attorney in Houston. Next year, I'll be a lawyer for 40 years. It's very interesting to me, I think, starting this and listening to the historical events. Unfortunately, I want to start with a little sad note. We lost two LGBT advocates recently, Johnny Peden and Pat Gandy, and they've just passed away. And in thinking about today, I was thinking that so much of what we do, the Lawrence versus Texas case, so many cases brought by Lambda, are really for the longevity of our movement. We all will be gone, some sooner than later, but eventually will be gone. And these cases and these precedents will live on. And I just wanted to start with that significant fact, because what we do and the steps we take and the accomplishments we achieve will live on and help generations to come. So I'm very happy to be here. I'm looking forward to talking about the details of the case and my friends John and Tyrone. But I wanted to start with that so that everybody really realizes the significance of what Lambda does and of a case like Lawrence versus Texas.
Hey, good morning. Glad to be with you all. After listening to Dick and Wesley, I'm just sort of reminded that, wow, we're old. We have been a part of it. So I was, as Dick said, I was on the THRF board when we conceived, implemented, and orchestrated Baker versus Wade. I was on the board when we did the Morales case, and I was on the board when we were working with Micah England. So I bring that context in this conversation because then just by some cool synergy, when Lawrence arose, I had come back to Dallas. Kevin Cathcart was the executive director at the time. He called me. I was working at, I went to divinity school, and I was working at Harvard as a dean. And he called and he asked me to come back to Dallas to launch the SCRO, and I did that. And just as we're doing that, Lawrence arose. So that's what I can add to the conversation is this sort of, it was synergistic that I was a part of the Baker case, the pre-cases, and then I got to be a part of Lawrence's, and I was the spokesperson and educator for the case.
On that note, would you like to provide people with an overview of Lawrence?
Just a few facts. So this is what the court said in the opinion in Lawrence. This is what the court said the issues were before the court. One was the validity of 2106. That's it. But then it said whether the issues were whether convictions violate the 14th Amendment guarantee of equal protection under the law. 2, whether convictions violate vital interests of liberty and privacy protected by the due process clause of the 14th Amendment, and whether Bowers versus Hardwick should be overruled. I think what Wes was saying is important for us to sort of keep in mind is the context. When Lambda is getting involved in cases, what they're doing is they're looking for where does the case fit in, how will it move the law? It isn't just was what happened wrong, but how will we move the law forward? What will be the impact of the case? And so when Lawrence is happening, it's in the context of a movement both around privacy and around equal protection. So the privacy cases were, as Wesley said, so we have Griswold, Eisenstadt, Roe. So Griswold was a case that arose in 1965 where members of the Planned Parenthood Committee in Connecticut were providing contraception education so that you would be able to prevent conception in Connecticut. That was found to be a violation of the law. They were arrested, but the Supreme Court held in that case that married couples should be allowed to make their own choice in their own bedroom without governmental intrusion. Following that, then in 1972 came Eisenstadt. And so what it is an extension. Massachusetts had a law preventing the distribution of contraceptives to unmarried people. So first Griswold married, now we move in Eisenstadt to married. So the court in that case extended the right of privacy from Griswold to unmarried people. Then comes Roe versus Wade. And what the court did there is the court said that this was a case we all know. And what the court said that if anything, a woman should have a fundamental right to make choices around an abortion, and that the government shouldn't be involved, that there was an extension of the right of privacy there. So then Bowers happens then in 1986. So a huge setback. Because in Bowers, what the court essentially was saying that we, gay people, have no constitutional right of privacy that others might have. We don't have that in our bedrooms. That's what the court was saying in Bowers. Then along equal protection, we had then a case that was very important between Bowers and when Lawrence came up, and that's Romer versus Evans. In Romer versus Evans, that's the Colorado Amendment 2 case, and that is that the people of Colorado got to take a vote on whether there could be an amendment prohibiting protection of LGBTQ plus people in a city's non-discrimination ordinance. The population of Colorado voted yes. We are going to prevent that by Amendment 2. We don't want gay people protected. The Supreme Court said, hey, if the Constitution means anything, it means that the majority can't vote to discriminate or withhold protections from a minority. So that's sort of a very quick overview of what the legal sort of I guess landscape was when Lawrence was decided. But then, so we know how the case comes out. We just saw the picture of the New York Times picture that Wesley put up. But this is how the court's opinion begins. This is beautiful. This is like one of those opinions that's just to read. I've been rereading it in the past few weeks. Here's how Justice Kennedy begins. Liberty protects the person from unwarranted governmental intrusions into a dwelling or other private places. In our tradition, the state is not omnipresent in the home. And there are other spheres of our lives and existence outside the home where the state should not be a dominant presence. Freedom extends beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. The instant case involves liberty of the person, both in its spatial and more transcendent dimensions. And this is how Justice Kennedy ends his opinion. Bowers was not correct when it was decided, and it's not correct today. It ought not to remain binding precedent. Bowers versus Hardwick should be, and is now, overruled. So, there's an important piece in the breadth of the opinion. In overruling Hardwick versus Bowers, Kennedy, in his opinion, was making an important point. So remember, the court could have gone on privacy under the due process. It could have gone under equal protection, again under the 14th Amendment. The court said it did not want to make a ruling just on equal protection because that would align it with Hardwick. And they didn't want the Texas legislature to come back and apply 2106 to both heterosexual and homosexual conduct. So the court said, we don't want to go with equal protection. Justice O'Connor, in her concurring opinion, did go with equal protection. But the majority said, no, we're not going to go with equal protection. We're going to flat out overrule Hardwick versus Bowers. So there is no mistake in what we're communicating. And that just like married couples, just like single couples with contract, LGBTQ plus people have a right of privacy into the sacredness of their homes. And so that's why the court said what it said in the opinion in the Lawrence case. So I think that is, I guess, a hopeful sort of context.
No, absolutely. Even then, I'm still learning things about Lawrence. Before we kick to Mitchell, in his involvement as a cooperating attorney with Lambda and his initial involvement in the case, I was hoping, Lee, you can talk just briefly about how Lambda picks cases and the care that goes into it. I got to see a lot of that at my time as a legal fellow, but I just wanted to let other folks in on kind of the magic behind the scenes.
So I know when I was the regional director, and Shelly could probably speak to a more current, because mine was a 20-year ago history. But what Lambda does is it isn't just making it. We would get calls that somebody said this wasn't right. But Lambda wasn't necessarily taking the case because it just wasn't right. It's, will the case have an impact on more than a singular individual? Will the case have an impact in developing law? So in Lawrence, part of what the decision was to accept Lawrence was to, with the complexion of the Supreme Court, and Lambda is paying attention to the breadth of it, the complexion of the court, the complexion of where we are culturally, looking at the movement across the nation and the world about where people had gone. And Lambda had the vision in Lawrence that by taking Lawrence, there was the opportunity to change the landscape for us and the architecture of our future.
Thank you. Now, Mitchell, you were the attorney on the ground. Would you like to talk a little bit about your involvement and how the case came about?
Sure. So, is this on? Yes. Okay. So, I graduated from South Texas College of Law in 1985, and Bowers v. Hardwick was released in 1986. And I was a 20-something gay attorney, ready to get out there and be a lawyer, And but unfortunately, the Supreme Court had said there was nothing I could really do to help gay people. And secondarily, as unfortunate as it was, as a new young lawyer, as a gay man, I was dealing with HIV and AIDS. Not personally, but as a lawyer. And so that is where I focused my next 10 years, is fighting discrimination in HIV and AIDS. I would go to Creating Change, and I would meet Lambda Legal attorneys. And this plays an important role in how this all came about. That's why I'm sharing it with you. And we became friends. Suzanne Goldberg was the Lambda Legal attorney that I would continue to see at different advocacy seminars, Lambda Legal would help, and she would provide sample pleadings to fight discrimination, et cetera. And I kind of was getting known in the Houston area for HIV and AIDS discrimination, legal assistance and representation. So I believe it was on September 28th, 1998, I got a call from Lane Lewis, who said, 2 guys just got arrested and put in jail last night for having sex. And as lawyers, we know we get lots of crazy calls, and they're never really what they say they are doing. I thought, well, they probably got arrested in Memorial Park or having drugs or doing something. So I really pushed it aside. I said, send me some paperwork and I'll check it out. And they, so what had happened was a gay clerk at the Justice of the Peace Court in Pasadena, Texas, is where the criminal case landed. They were friends with Lane Lewis. Lane Lewis worked with Queer Nation and ACT UP, and so he knew my work with the HIV/AIDS community. And he faxed me the probable cause affidavit. Now, I had never seen a probable cause affidavit because I'm a real estate attorney, and I handle real estate litigation. But of course, they were arrested in John's apartment, so I considered this a real estate case. So, anyways, I was able to read the probable cause affidavit, and there it was. The only charge for both of them was violation of 2106. And I said, sure, I'll be happy to meet with them, send them over. So the next morning, 3 gentlemen arrived at my office, and I was a little confused because I was expecting John and Tyrone, but there was also Robert Hughbanks. And they all came into my office and sat down and started telling me what had happened the night before. And Robert Hughbanks was actually the boyfriend of Tyrone Gardner. Tyrone and John had had an argument, and I can tell you about that more if you're interested. And Tyrone and Robert, his boyfriend, had an argument over something. John was inviting them to spend the night. They were going to be moving furniture the next day, lots of normal life details. But Robert is the one who called the police. He called the police and said there was a man with a gun in the apartment, please come quick. The police arrived, he opened the door, he let the police into the apartment, and the sheriff deputies swore that John and Tyrone were engaged in anal intercourse. And at 2 or 3 o'clock in the morning, they called the district attorney's office, got approval for arresting them, took them to jail, and got them very angry. Had they not been arrested, they probably would not have hired lawyers. They would have probably done some plea and be done with it. But they were all sitting there that morning in my office, and I asked Robert to go sit in the hallway because I wasn't going to represent him, but I would represent John and Tyrone. And so I got the facts, and I guess I'll share the facts at this point. They told me they weren't having sex, and I said, okay, well, we're not gonna try to get you acquitted on this criminal charge based on facts. We're gonna need you to plead no contest, that you are gonna have to stay quiet. We are gonna have to just tell the police that we're gonna go with the police officer's sworn testimony, and we're gonna try to challenge the law, 2106, if you're willing to do that. And they both agreed to that. So I left the conference room, went and called my friend Suzanne Goldberg in New York at Lambda Legal. And I told her what was going on. I faxed her the probable cause affidavit, and she said, Mitchell, you are in luck. Today is the day that we have you may know the name of this. They have a weekly planning meeting where they decide on what cases they're going to take. And they said this afternoon is the day we have our meeting to decide what cases we want to take. And I'll present this afternoon to whatever group is deciding this, and I'll let you know. Well, she called me back later that day and said, we want to take this case. We will be the lead constitutional lawyers. If you'll be the local counsel, we'll work with you. We'll provide the constitutional expertise, and you provide the local assistance. And I'll send you over the agreements for everybody to sign, and let's get this signed up. Because we had our first arraignment in or our little trial in the Justice of the Peace Court coming up. And so we got everybody signed up. John and Tyrone understood what was going to go on. I thought I understood what I was doing, which was just being the local attorney, assisting on everything. And we went to our first hearing. So that's kind of the background. I'm happy to go. I can tell you every hearing we went to, what happened, can tell you all the things that occurred with the media, the local or the Texas political Republican Party. Lots of drama. You know what? They should make a movie out of this.
They really should, honestly.
Actually, they are making a movie out of this.
I didn't know that.
I was going to tell you, there is a script that's written. We are finding a production company in LA. We have, I can tell you more details, a little bit of the details, but we're going to be starting filming this show probably within the next year. They even have some stars cast in it, and I'm really not sure what I'm allowed to tell you, so I'll be quiet, but I was joking. They are making a movie, and there's so much drama, so much interesting things, and we'll be talking more about it, but you heard it here first, okay?
Let's talk. Let's talk about kind of the legal strategy behind its way to the Supreme Court and the ultimate decision.
Okay. Well, I had no idea what involved going to the Supreme Court. Thank God Lambda Legal was there. For our first hearing, Suzanne Goldberg flew down, and it was a blessing she did. The reason is we pled no contest at that very first Justice of the Peace Court hearing. The Justice of the Peace Court didn't really know what to do with this. They had never handled a case like this before either. So we pled no contest. Judge Parrott fined everybody $100, and we were heading out to the parking lot. There was one protester out in the parking lot. Of course, the Houston Chronicle was documenting every step. We were on the front page of the Chronicle. John and Tyrone's mugshots were there. But before we left, Suzanne was on her phone and realized that an initial mistake had already been made. You cannot go to the United States Supreme Court for a $100 fine. The fine has to be above a certain amount. So we turned around, went back into the court's office and said, Your Honor, we need to go back into court and you need to raise the fine. I think it was $250, might have been $300, but Suzanne knew. We went in, had him raise the fine for each of the guys. Lambda Legal paid it, and that was the first potential error that was averted because Lambda Legal was on the case and knew what was going on. I guess I also want to talk about the fact that due to the media and my work with HIV and AIDS, I knew a lot of the LGBT lawyers at a lot of the firms, and people kind of knew what was coming, like heading to the Supreme Court. It would be many years. And they were afraid. They were afraid because of Bowers v. Hardwick, which had just been issued. So this was 1998. Bowers v. Hardwick was 1986. And that loss was fresh on everybody's mind. And although I know we think we have a pretty conservative court at the Supreme Court today, many people thought the Supreme Court was still conservative. Don't do this. Don't try it. You're going to get another bad decision, and we're going to be locked into this terrible situation for a long time. So we had to deal with that. And Lambda Legal, thank goodness, had the expertise to know that it was worth trying. They had known about Justice Kennedy. So with Lambda Legal's guidance, we decided we're gonna continue on and go forward.
And eventually, you all did get a lot of support. I know there was a coordinated effort in regards to amicuses at the Supreme Court level. Do either of y'all want to talk about that?
So when you're going to the Supreme Court, there's a lot of strategy in terms of who is going to argue the case. How do you present the full package to the Supreme Court? At the time of the Lawrence case, Ruth Harlow was Lambda's legal director. Pat Logue was the regional director and a sort of legal brain in Chicago. And what their preliminary decision is who is going to argue the case. When I think back on this, to me, Ruth and Pat were they're unspoken heroes in Lambda. Obviously, every single legal strategy was launched by Lambda, and particularly with Ruth and Pat. Suzanne was involved in it. But Ruth and Pat, from the time it said moving to the Supreme Court, were making every single decision. So then they had to make a decision as who's going to argue the case. You can only imagine that this is the argument of a lifetime. And so to relinquish the case, you really have to be something. And Pat and Ruth together thought about it, and they decided, okay, here's what we need to do. We're going to relinquish the case, and this is why. So what we had heard in the Bowers case, we had heard that over the weekend, Bowers initially was decided one way, where Justice Stevens' opinion was going to be the majority. But over the weekend, it changed. And one of the things that we had heard was that the Supreme Court was thinking that it was sort of like John Cornyn. When John Cornyn is ruling in the Texas Supreme Court case, it's as if he doesn't know any gay people. He and I went to law school together. It's sort of like that. And so part of it as a practical matter, what we wanted to make sure is we didn't want a Hardwick situation where the Supreme Court thought they didn't know any gay people. And so what happened is Ruth and Pat identified Paul Smith to argue the case. Paul had been a briefing attorney for the Supreme Court. When he was briefing attorney, he was in a heterosexual marriage. He had left that marriage, and in the time between then and when this argument was coming around, Paul was a well and talented Supreme Court lawyer, but we also knew the Supreme Court knew his personal history. So we didn't want to trip on what we heard was a trip in the Bowers versus Hardwick. And so what happened is that Ruth and Pat then made this decision with Paul. Paul is sophisticated. If you listen to the argument, it is a brilliant argument. But I think we always have to remember that it's Lambda-led, Lambda-designed. And I'm not doing that because I'm a gigantic Lambda fan, which I am. But it's also because I think this is what's happening behind the scenes that sometimes isn't known. I was invited to come onto a Zoom call about 3 or 4 years ago, and the host of the call was going to have Paul Smith. And he was he said, I want to introduce Paul as the hero of the gay community, as the hero of Lawrence, as the person who conceived and orchestrated Lawrence. And it's a misconception. And so I went and did a correction. I wanted to make sure we were aware of this. So what happened then in preparing for the argument, Paul has absolute fluency in constitutional law. But what we were worried about in preparing for the argument was having fluency in LGBTQ plus culture. We wanted to make sure we expected questions that wouldn't have anything to do with constitutional law and would go wandering away, which they did. And we wanted Paul to be able to be prepared. So for weeks before the argument, Pat, Ruth, and others, and more of us worked with Paul in doing mock arguments, in doing cultural education, and we were doing that. We were also, as part of the strategy, we were also getting together amicus briefs. Amicus briefs are friend of the court. So what happens is when a case is at the Supreme Court, people who have any interest whatsoever can decide they're going to file an amicus brief. And so Lambda was orchestrating briefs from history briefs, civil human rights briefs, religious briefs. We were doing this across the country and getting these organized. The SCRO's particular role in the amicus briefing was in putting together the religious brief. Brian Chase was the Lambda lawyer at the time. Brian and I were working, I'd gone to divinity school. We were working with religious organizations across the country to do that and bringing forward that voice. So that was part of the strategy as we're approaching the argument, is in preparing the briefs, in preparing the amici, and preparing the lawyer who's going to argue the case. And it was a concentrated, all hands on deck, this is what we were doing, total focus.
Now that was the in-courtroom strategy. I know so much goes on outside of it, and you wore the head of education back then. Do you want to talk a little bit about, efforts with the media and other things like that?
Sure. Cece's here today. Cece, you can probably remember this. One of the things that we did together is we went to the Dallas Morning News. This was one of the strategies for Lambda is we wanted, part of what can happen in a Supreme Court case is, yes, it can be based on precedent. Yes, it can be based on law, but it's also based on culture. And it's based on the court can look at what's going on. And so part of what we had an intention to do is we wanted the court to be aware that there was a cultural shift. It wasn't where it was in 1986 with Bowers versus Hardwick. We wanted to have the court see where it was. So part of my role was to creating meetings with editorial boards across the region and then working with other people across the country. Cece was great. Cece was, in one of her former careers, she was a journalist. She understood it inside out. She helped us prepare. She and I went before the editorial board of the Dallas Morning News. And I'll say this, I think it was a good meeting, but it was disappointing because the Dallas Morning News didn't publish the editorial until the day after the opinion was rendered. I also went to the Tulsa World in Tulsa. This was an amazing thing. The board, they were so well prepared. I was peppered with questions. And they were well prepared. But listen to what the Tulsa World did. On Easter Sunday, they did a lengthy editorial, completely pro Lambda's position, completely pro-liberty, completely pro-equal protection. It was an amazing editorial. And those editorials were going on across the country. I was also being invited to go to universities, into city councils, into board meetings, to be talking about Lambda. And to talking about the Lawrence case. So I'll tell you just, probably my most memorable experience. When Lambda offered me the job to be the SCRO regional director to help launch the SCRO, I was telling my then 80-year-old uncle, who I thought was really old then, and now I think is a spring chicken. I was telling him about it, and he said, is this dangerous? And I was like, no, it's not dangerous. So now here I am, I'm educating on Lawrence. I go to Topeka, I'm going to Washburn University. I'm by myself, I'm the speaker, and I was traveling all over the place, and that was what I was doing. But I arrive, and there is Fred Phelps and his band of hate mongers. There are 300 people. There's a single sidewalk up to the door where I'm going into the lecture. And they're on both sides screaming every single epithet you can imagine. And all of a sudden I was sort of hearing my uncle, I went, whoa, yeah, maybe this is dangerous. But it was powerful what we got to do, universities, getting to do the education, getting to talk about it. It's as when Dick was talking about this morning that there was an electricity. That's what it was like. There was an electricity around this case, just everywhere, right, Mitchell?
Absolutely. So I think, we jumped right to the Supreme Court case, but there were years of battles at the lower court levels that were important as well. Of course, we lost at every court, except temporarily. And it was really interesting to hear the history this morning because Ruth Harlow and Lambda Legal had argued at the Court of Appeals in Houston some of the arguments that we ultimately won on at the Supreme Court. But we won. The 14th Court of Appeals actually issued a decision based upon the Texas Equal Rights Amendment, which I do not believe we ever argued. But now I hear that was the basis of a prior decision, so that must be where they got it from. But we won. And then the district attorney's office filed a motion for en banc review, which was granted, and then John and Tyrone were convicted as well. So I think it's important to know that we went to the county court, the appellate court, and then the Texas Court of Criminal Appeals, which is the Supreme Court for criminal cases. So it took years to get through there. And all through these years, John and Tyrone were very frustrated because people thought they were a couple. People thought that they were having sex. And there was one time with the media where they wanted to hear from our clients. They didn't want to hear from Lee and I. We would come out, we would talk at press conferences, and John Lawrence went up to the microphone once. We said, "Okay, we'll let you talk for just a moment." And they said, "John, how do you feel about this case?" And he said, "We weren't doing anything wrong." I said, "Okay, thank you. Go back, John. Go back to that." But that's truly how he felt. He said, and you now know why he said that. But the education of this, I want to share something just between us, okay? I had never thought of going to the Supreme Court. I wasn't even licensed at the Supreme Court when this case started. And there are a lot of good cases that don't get selected to go to the Supreme Court. So the chances of this case actually going to the Supreme Court after Bowers v. Hardwick was granted so recently, I didn't really think this was going to happen, folks. So I really did not imagine the outcome of this case. But what I did find out is that people were shocked to hear that gay people could be arrested. We were getting calls from all over the world, from France, from Germany, from California, from everywhere saying, "Is this real? Did this really happen? And could it happen again?" And at the time it started, there were 15 states that had similar laws. The time the Lawrence decision came out, I think there were 13 states. But the biggest advancement of this case and of John and Tyrone being willing to have their names and faces is the education of this. And so I know Lambda hated when I would say this, but I don't really care if we won or lost. It was the education of people knowing that this was possible, that LGBT people were being criminalized, and how unfair and how this was wrong. And so I know that some of us are concerned about this Supreme Court and this Supreme Court undoing what Lawrence versus Texas, the Lawrence versus Texas decision, undoing the legal protections of that. And certainly I agree. I married my partner too, and we want to stay married, and we don't want Lawrence versus Texas going away. And I don't think it will. But if the worst were to happen, there is no way that anybody can undo the education, the acceptance, the love of a majority of the American people and of the world, which is truly the effect of the Lawrence versus Texas decision. There is no going back on that. Yes, we want to preserve the legal rights, but the education and the between the terrible HIV and AIDS crisis and the Lawrence versus Texas decision and the coming out of gay and lesbian people, the assimilation, the normalization of LGBT people, I mean, all of those things, that's here forever and going to go forward. So I just wanted to make that point because the education and the acceptance of people as a result of this case and the other things that Lambda and the HIV advocates did is here forever. So I just wanted to remind you of the importance of that, whether we won or we didn't win, and of course we did win. And why don't we talk about the Supreme Court now?
Yeah, and I'll just add this, that educational piece is very, very important. I think the panelists from earlier talked about how it was more than just that statute. And if you listen to the oral arguments, they're online, I think on YouTube, they talk about how it's not just this statute, it's so much more. It's about, the environment we're in, what folks truly want. And I think that educational piece was super crucial to getting the ultimate decision, which we all know was, right.
And I think it's important to say that's part of Lambda's strategy. Mm-hmm. Lambda knows there's a cultural component, there's a PR component, whether it's picking Paul Smith or the media interviews and the television interviews, all of those things, I think, and I'm not as involved with Lambda as these gentlemen are, but the Lambda concept is to move the country forward as well as the legal developments. Would you agree with that, Lee? Sure. Okay.
Entirely. So the decision came down June 26, 2003. I was just 7 back then. I was 7. The 626 I remember is actually the marriage cases. And shortly after that decision came out, it was Houston Pride Weekend. And I remember everything about not only that day, but the days after that. It was my first Pride I've ever attended. I think, Mitchell, you were there the day the decision came out. Do you want to talk a little bit about Lawrence in 626, 2003?
Okay. Well, I actually wasn't in Washington. I was in my office at my desk with TV crews all around the building. And my mother called and said, "Son, you won." And I said, "Mom, let me wait for a call because the Lambda people in Washington were calling me." And it was amazing. As Lee said, if you haven't read the Lawrence versus Texas decision, please read it. Time magazine has identified it as one of the top 10 controversial, most important constitutional Supreme Court decisions. But it was glowing. It was amazing. Different parts of that, from overturning Bowers v. Hardwick to Justice Kennedy's language about respect and dignity for our relationships and our self-determination were amazing. When we traveled around the country speaking at universities and law schools, people would ask us, "Does this mean you're going to get gay marriage?" And this is part of the strategy because I was very honored and blessed to be included in the strategy calls, in the conference calls, in the drafts of the pleadings. It was such an honor for me to be included by Lambda, to be part of the team. And I'll share with you now that part of that strategy was to stay as far away from gay marriage as possible. Because this was 2003, we did not want anybody to think that this was the gay marriage case. But underneath, there was that possibility. So when we were asked after the decision came out whether this meant gay marriage was in the future, I would say, well, I'm not a constitutional lawyer, but Justice Scalia is, or Justice Scalia is a constitutional expert, and that's what his dissent was all about, is that if the Supreme Court is right that gay and lesbian people have the same constitutional rights as everyone else, then they have a right to the fundamental right of getting married. And in 2015, the Supreme Court, based upon the Lawrence versus Texas decision, decided to grant marriage for everyone, marriage equality, thanks to the Obergefell decision, and that's how history has it.
Amazing. Now, when kind of speaking about the legacy, when I helped litigate some of the Texas cases that we have now, or Lambda has now, Doe v. Abbott and P. Flagg v. Abbott, cases which sought to protect families from being investigated by the state of Texas simply for supporting their transgender children, I looked at Lawrence as a source of hope and inspiration. Lee, would you mind sharing what you wish people think back about, what people can take away from Lawrence and kind of any concerns you have with Lawrence now?
I guess some hopes that I have about Lawrence is never say never. You know, when Hardwick was decided, it was so dark. I mean, there was the decision was it was as bad as it gets. Who would have ever thought in a lifetime that we would move from Bowers versus Hardwick to Lawrence and Garner versus Texas? So I think that one thing is that I guess my hope is that we all remember that every single thing we're doing matters. I think what Wesley said is important for us to remember, that Baker versus Wade and the cases that preceded Baker versus Wade mattered. We had admissions that we obtained from Morales were used when we got to the Lawrence case. And so there is a building. And so even when we're being defeated, I think that we have to remember that it matters what we're doing because we're paying attention to what we're looking for, to where we're looking for in the future. So that's one thing that I hope would be just sort of the value of our everyday effort, and in the midst of defeat to still go forward. I also think it's really important that we all, and I don't know how we educate across our community, but our community needs to understand we're always voting for the Supreme Court. When you read the Dobbs opinion and you read Thomas's concurring opinion, I don't know that I'm as optimistic as others that I've heard. Clarence Thomas is unambiguous in his concurring opinion that what he wants to do is he wants a bullseye on Griswold. He wants a bullseye on Lawrence. He, I think, in a heartbeat, and when you look at the super conservative majority that's on the Supreme Court, in a heartbeat, what he would like to do is he would like to eradicate these cases that are founded on liberty. And I don't think that it would bother him for a second, the chaos that would create in our lives. I think that's the thing that I worry about. We hope and we like to think that reason will prevail. But I think that we have to be aware of it. When I read his concurring opinions, I shuddered. I guess the last thing I'd say that in terms of sort of impact is that make your life matter. Make what you do matter. Volunteer, make your work do this. I think that for me, what I think about is I think about all the shoulders that we were standing on when we got to Lawrence. All of the work that got us to Lawrence. I look at all of the shoulders, those that got to marriage, those where we are today, the shoulders we're standing on. What I know for myself in this is I am so grateful in my life. I mean, what happens when you get old is one of the things is you look backwards and you say, so what mattered? What were the pivot points? What am I glad that I did? You know, what am I most glad? This is one of the places in my life I'm most glad that somehow I was called into this work. And I know that when I pass, you know, no one's going to remember me, but the work that we did will matter. So lend your shoulder. Be a shoulder on what other people are standing on. I guess those are the impacts that I hope for.
Amazing. And I'm just so honored to be here with you and also you as well, Mitchell, in regards to your legacy and your piece in this, you know, greater case and greater LGBT right movement. What do you hope people remember?
There are two final points I'd like to make. The first is, please remember that John Lawrence and Tyrone Gardner were just regular gay guys, okay? Regular guys. And they had an opportunity, something terrible had happened to them, and they were willing to stand up. They were not LGBT advocates or lawyers. They were just regular working guys. And they did not have confidential phone numbers, did not have confidential addresses. And I will tell you, it took about 5 years for this all to transpire. They were treated as guests, they were held high by the community, including law enforcement. And they never had one negative thing occur to them throughout their entire lives as a result of being the named defendants in this case. And so I tell that to people who are afraid to come out, who are afraid to do something, even though they know it's that there's something that they could do to help. Is if John Lawrence and Tyrone Gardner were willing to put their names and their lives on the line for us, and nothing bad happened to them, we should have that same courage to do whatever's going to come next. So I wanted to share that with you and hopefully encourage you to do the right thing. The last thing I want to say is that I was well aware, as I was experiencing and helping in whatever way I could, that I was experiencing history. History that I'll always remember and history that will live on. Are we all aware that we are experiencing history now? Right now, in the next few months. This is an amazing period to be alive. An amazing period to be able to vote. And this Lawrence versus Texas just celebrated 21 years of the decision. With me today is my daughter, who is 22 years old. Those dates matter. That means my child was 1 year old when I was involved, and younger. I had adopted her and her brother during the 5 years of Lawrence versus Texas. And so people would ask, why are you doing this? What are you doing this for? And I would say, for my children. And I was fortunate enough to get children. And that's probably, I know not everybody has children, but they're all children, whether they're our children or not. The children, the young people of our country, of our world, are benefiting by what we do, including what's about to happen in the next few months. So I'm very excited. I know, the election and all that is not a legal thing, not a Lambda Legal thing, but it has effect, and it'll have effect on all of our lives. And I just wanted to say, this is history that we are living. And I just want you to take every moment in, just like we did in Lawrence versus Texas. It was so exciting to be a part of this every step of the way. And we're all sharing what's about to happen over the next few months. And I hope, just like in Lawrence versus Texas, that when it's over, we'll all be able to celebrate. Thank you.
Thank you both, and thank you all for having us. Gonna pass it to Shelly for Q&A.
All right, y'all.
Hey, Shelly.
Yep.
Before we start, did we get it right when we talked about how Lambda picks cases and sort of that? I mean, is there anything you think you'd like to add and to sort of help educate on that piece?
I can't tell you. I'd have to kill you. No, kidding. I think Paul Castillo is here, and he's going to be on our panel this afternoon at 2:15. And so let me turn it over to Paul and let him quickly answer that question, and then we'll keep taking some more questions. And Paul, please introduce yourself as well.
Sure. Thank you all. My name's Paul Castillo. I use he, him pronouns. I'm the Deputy Legal Director for Legal Education and Public Engagement, and I'm based right here at the South Central Regional Office in Dallas. And you're absolutely right. With regard to the care, the discussions that we have within the legal department meetings, which occur on a weekly basis, we help the community, and certainly we get some of our cases by the fact that we have a help desk for people to call in and look for resources, and as has been said today, we can't take all the cases, but that is one place where we learn about what's happening in the community, what's happening on the ground. We also have connections with attorneys all across the country, and the relationships we build at various conferences as well. And so as these cases are coming to our attention, even before we get to the legal department meeting, I think that the Lawrence versus Texas had a time urgency to it, right? But for a lot of these cases, before we even get to the legal department meeting where this is discussed and debated, and how does this connect to the broader movement, we are doing our legal research. We are sort of kicking the tires and kind of looking at back and forth. So we do have those legal department meetings, and I'm just so blessed to be in that environment. But in addition to Lambda Legal, I do want to call out that this is our grassroots community. It is our community providing us the stories of their experiences, and our sibling organizations. We have the round table, a lot of our sibling organizations we get together with quite regularly to discuss sort of what does this look like 5, 10, 20 years down the road, should we take these various paths?
Great answer, thank you. And I think only one quick add to that is it really, when we work up cases, we're making sure that we're pulling in our partners that represent the lived experiences of the people that are in the cases that we want to take. And we go to the folks in the communities to make sure that if we're going to work on a case, that we're not going to create harm that we may not recognize because we're not there on the ground. And so we try to really partner with folks across the board as we do our cases. So any other questions, y'all? These are legends. I mean, this is what I just heard. Any others? Yeah, okay. Well, Christopher Walter here, and maybe make sure everybody can introduce yourself as well.
Hi, I'm Christopher Walter. Sorry about my mic. Past president of the LGBT Bar Association and past chair of the LGBT Law Section of State Bar of Texas. Would you like to talk a little bit about the efforts to repeal 2106, especially post-Lawrence, and how that went?
I'm not, I can't really speak to that. There's going to be a section this afternoon on legislation. I imagine this afternoon that they can talk more directly about what those efforts have been.
Okay. Shelly, yeah.
One thing I want to tie up too is I think we heard Wesley and Dick Peoples talking about Micah England calling William Wayborn, and I think Lee was telling a story about William Wayburn and Paul Smith, and William Wayburn thinking that Paul Smith was the architect of Lambda Legal. And so I think it's listening to all these names that you're hearing the same names over and over and over again of folks that have been involved in this movement for years and years. And so I think it's just neat to acknowledge that. Lee, if you would, just real briefly, there was one question that the Supreme Court asked Paul Smith that you all were able to kind of help him work through, and I think it had to do with teachers. And so go ahead.
So this is at the argument, and Mitchell, we were there. I wanted to say one thing about the argument. This is something that was super cool. So when you're at the Supreme Court, they put quills on the lawyers' desks. And the quills are on the lawyers' desks to remind them that you're in a historical moment. And so the lawyers, Paul and Ruth and Pat, handed one quill to Mitchell, and then they handed the other quill to me. And when they handed the quill to me, they said, well, Lee, we're handing this to you because you've been at this the longest. So there I am in the Supreme Court and just burst into tears. I mean, that's what happened with that. So the argument was, the argument goes, Paul leads, then Rosenthal responds, and Paul reserved 4 minutes at the end. In the argument, what it was almost as if Rehnquist and Scalia had decided that Rehnquist was going to tackle the due process privacy question, and that Scalia was going to tackle the equal protection question. So Rehnquist was trying to establish through his questions how there's a long-standing history in the United States and the world to have sodomy laws, particularly that particularize homosexuality, and it wasn't accurate. The Texas statute was a 1973 statute. So that's what happened in that Q&A. That's where he went with that. But there was a hostility that was palpable in it. When you listen to the arguments, there was this hostility. So here's this Q&A that started. So what Scalia was doing, he was trying to push Paul to agree that there might be a legitimate state interest in having a law that was focused only on homosexual contact, so that there would be a reason to justify unequal treatment. And so, I was writing this down because I thought this would be of interest. Scalia says, couldn't the state prefer heterosexuals to teach kindergarten rather than homosexuals? So this is the cultural piece I'm talking about. There was a part where Scalia started talking about flagpole sitting. So he's coming out, and this is why Paul had to be educated, because this is where we're going. Paul said, well, they could, but they would need justification. And then Scalia says, well, the justification is the disapproval of homosexuality. And then Paul says, it needs more. You have to show harm to children. Well, so here's where Scalia goes. This is what it was like then. Well, isn't the justification that children would be induced to follow the path of homosexuality if they had a homosexual teacher? Wouldn't that be enough? That's what he says. And then Paul started, and it's a longer answer, but he says his starting place is the state has to have a greater justification than just pushing people toward heterosexuality. So that's where it starts. It's an argument that I think, so I've read the argument and I've listened to it. I think listening to it, you can stay with it. I think reading it was a little complex, but it's as we said, this opinion is, you've got to read it, and I think you ought to listen to it.
And I'll add, online they have a video where you can listen and read at the same time, and they have some really good tidbits in it. Just thinking back about what they said, like, hey, if they want the law repealed, just go through the legislative process. It can happen. And then now we're sitting here in 2024, and we still have it on the books. So there's really good, nuggets in there. So I definitely encourage folks to go and listen.
Okay. I'm going to let each one of you just give us a quick wrap up, although this has been just amazing. And then before we do that, we're going to have lunch out just outside of the theater here. And so we're going to have a lunch hour from about 12:15-ish till about 1:15-ish. And then we'll start back with our legislative panel. So we have Miriam Lakey here from Equality Texas. We also have Representative Jessica Gonzalez, who will be here with us, and then Cece Cox will be moderating that panel. And then at 2:15, we'll have three amazing Lambda Legal lawyers who are going to be talking about the cases right now that are going to affect our futures. And then after that, everybody has free admission to the museum. And your welcome museum is open until 5 o'clock. And there are also little cards that will be out here on the table that show you where in the museum there are LGBTQ specific parts that are exhibits. So please enjoy your time here. This museum is amazing. And then I think, do you want a 30-second wrap up, each one of you?
Thank you all for coming. You have a particular interest in this. I want to remind you that you too can go to the United States Supreme Court and sit in and watch oral arguments. On the morning of the Lawrence versus Texas case, John and I traveled to Washington, D.C. We arrived at the Supreme Court before sunrise. There were college students who had slept out on the sidewalk for days because they only have 50 seats for the public to go in. And so, not that I'm into drama or anything, but what I did is I took John around to the sleeping college students in their sleeping bags, and as they woke up, we walked around and welcomed them, and I said, hey, why are you here? And said, we're here to see the Lawrence versus Texas decision. I said, well, here's John Lawrence if you'd like to ask him any questions. And so it was really cool for the students and also for John to see these people who had slept on the sidewalk for days so that they were sure to get a seat in the Supreme Court. If you're a lawyer, there's a separate entrance for lawyers. If you're not a lawyer and you're still interested, there's a public entrance. So I've been to about 4 different Supreme Court decisions since the Lawrence versus Texas decision. It's really fun to watch history in action.
Again, thank you all for having me. I'm just so grateful to be up here with these two living legends. For me, I know Lawrence versus Texas was a national case, but it hits very close to home. And right now we have a fight here in Texas in regards to trans rights. So being able to look back at Lawrence versus Texas and having it be, right here or not here in Houston, but right here in Texas, just really grateful for the both of you all.
Guilly, thanks for moderating. Mitchell, glad to be here with you. I guess my hope is in Guilly and the generations that are coming up, that they will do this work, that they'll carry this work forward. I'm grateful for Lambda. My first engagement with Lambda was in the late 1970s. It wasn't social media. A group of lawyers from around the country, we had what was called the Round Table. We flew to New York on a quarterly basis. Lambda had 2 little offices and 2 lawyers then. And what we did is we talked about cases that were coming up. When we were doing the Baker case, I didn't remember that Lambda was involved in Bowers the way that Wesley described that it was. But I remember that when we were doing Baker, that we brought it to the Round Table, and people were really nervous. They did not want to support us in doing it. And so it was, and their caution proved prescient when you see what happened in the Bowers versus Hardwick case. But Lambda has been there every step of the way. These cases that we're talking about, you know, the cases that matter, Romer, Hardwick. I mean, that we had Hardwick, we have Romer, we have this progression to Lawrence. We have our future. It turns into, you know, translitigation is a threat now. We are safe because of the work that's happened in the courts. That's why we're safe. We have to remember we do not have the legislation that protects us the way that the courts have. The courts, it's so fragile. It's so fragile right now. My hope is that we educate, that we have people understand how important this work is. We have to be grateful to the Don Bakers, the Linda Moraleses, the Micah Englands, the John Lawrence, the Tyrone, and John Lawrence and Tyrone Garner. We have to be thankful that they were willing to put themselves out there. And I'm thankful to all of you for being here and the invitation to be here with you today. Thanks so much.
Thanks, Phil. Lunchtime.